So are we live, y'all? Are we live, everybody? Oh, what? Yes, let's get into this intellectual property. So, welcome to Shirley TV, and I am Shirley. I am Shirley. Welcome to Shirley TV. Glad to see you. Glad you could be here. Glad you could join me. So I just wanted to talk a little bit about intellectual property, intellectual property law, and your intellectual property rights when it comes to you, your intellectual property, your business's intellectual property. Uh, uh, ah! So let's get started. First of all, what is intellectual property? So it don't consider, but it includes the creations of the mind, the creations of your mind, your intellectual property. So your intellect is your mind. Things that you have created, in a mental state, your mind, intellectual property. Let's get it somewhere. So intellectual property is a broad categorical description for a set of intangible assets owned and legally protected by a company or individual from outside use or implementation without consent. An intangible asset is a non-physical asset that a company or person owns. So, in other words, if you write a book, you created this book, uh, you wrote this book, you created this book, creations of the mind. You created this book from a mental standpoint. So that writing the book uh, will be considered your, intellectual property. What? You have your trademarks, your patents, and your copyrights. So I want to get into all three of those because those three are all creations of the mind and are considered to be your intellectual property. Your intellectual property gives you the ownership, gives you the right to use those intellectual property items. You can use them, make money off of them, and no one else has the right to come in and infringe on your intellectual property, rights. Your books, your movies, your copyrights, your patents, and your trademarks. So, let's get back into it. The concept of intellectual property relates to the fact that certain products of human intellect, right, your mind, should be afforded the same protective rights that apply to physical property, which are called tangible assets. So in other words, you own a car, you own a house, you own a car, you own a house, you own some land. Those are all tangible, I guess, intellectual property. But intangible are those uh, creations of the mind. So if you create something, you thought about writing a book, you wrote it down on paper and you wrote 5 or 6 pages, or even if you wrote one page, uh, according to uh, according to the law, you once you write it down, you have that ownership. In other words, if I write one page, two pages, 3 pages, or whatever, how many pages I write for my book, I am still the owner of that copyright. But when I when I get it legally, if I go to the United States Patent and Trademark Office, copyright, trademark, patent, USPTO, and I get a legal copyright, that gives me, legal protection in case someone tries to infringe on my copyright. And then so, but once you write it down, once you start writing it, you are the owner of that copyright. So, but if it's good. They always say it's good to, get it legally, copyrighted. That gives you more protection, gives you more legal protection. Because what if somebody come in and say you wrote a book, and then somebody come in and say, "No, that's my book. I wrote that 2 years before you wrote it." So it's still good, even though you wrote it. You have it on paper, and you started the book, or you finished the book. So they say once you start writing it, and once you start writing it down on that paper, then it belongs to you. You are the owner of that copyright. So let's get back into it. So intellectual property is an umbrella term for a set of intangible assets that are not physical in nature. Right, like I said, like in other words, if you own land, a house, or buildings, or cars, uh, those would be tangible. That's tangible property, but in your intangible intellectual property are your creations of the mind, your mind, my mind, somebody's mind. It can consist of many types of assets, including, like I said, trademarks, patents, and copyright. So you have an invention that will come under a patent. You have that's still a creation of your mind. So you have a patent, that's an invention. You have a copyright, you wrote a book, you wrote a movie. You have a trademark. Your trademark is that distinguishable mark. In other words, you have a business, you're selling some products and services, and you have a trademark, that distinguishable mark that distinguishes your brand, your company brand from the next company's brand. Like we have McDonald's over here, and Wendy's, and Church's Chicken, and Popeyes. So they are what you call fast food restaurants, and they all have their distinguishable trademark, trade name that distinguishes their brand from the next company's brand. So you can't, you know, open up a restaurant and think you're going to use the same trademark, trade name of a McDonald's or Wendy's or, we have KFC, Kentucky Fried Chicken, different, different fast food restaurants. So you have to make sure what you're doing. Make sure you have all the information that you need before you, venture off and try to, use somebody else's trademark, trade name. Just what if I have a business and my business is Shirley TV? My business is Shirley TV, so I have been using my business name, in commerce. I've been making money off Shirley TV, selling my T-shirts with Shirley TV on, and selling this, selling that. So I have already been using that brand name in commerce, so that automatically gives me, my trademark rights. But so I'll get back into a little bit more of, trademarks. I'm not a trademark lawyer or copyright lawyer or what's that, a patent lawyer, nothing. I'm just somebody that just love to do research, and I just like to learn. So my degree downstairs university was business administration. Yes, business administration and information systems. So let me get into it a little more. Let me see, did I read this? It says legal protections for most intellectual property expire after some time, but last forever for others. Understanding the intellectual property. Intellectual property, let me see, did I read this? Hold up. I don't want to read the same thing or no, I didn't. No, I didn't read that yet. Okay, I did read what is intellectual property. Okay, intellectual property is a category of assets that are intangible. Intangible means you can't touch them. So your intellectual property, that those are your creations of your mind. Creations of the mind, your mind, my mind. So intellectual property law. So that would be a good field to go into. I would love to be an intellectual property lawyer. Now, I have a few videos to share from a intellectual property lawyer. Okay, and where I stop at? Oh, this means that they cannot be held and don't necessarily have a physical presence. Like I said, land, you have houses, you have buildings, you have equipment, you have, your tangible intellectual property. But your intangible intellectual property, like they said, will be, your creations of the mind. These assets are created using human intellect, right? Your mind, human intellect. We're not talking about, you know what? Also, I want to get into maybe in my next video, artificial intelligence. What rights do these artificial intelligent machines have? What rights do they have when it comes to intellectual property? Then what are their intellectual property rights? Or I would love to do it. Maybe I'll do. Maybe that'll be my next video. Intellectual property can take many forms and includes things like artwork, symbols, logos, brand names. Right, like I said, your brand name. Your brand name would be, you have a logo. You have a logo. You have a trademark. So that would be part of your brand name. You know, so you have your brand, you have your artwork, your symbols, your logos, your brand names, and designs, among others. Companies are diligent when it comes to identifying and protecting intellectual property because it holds such high value in today's increasingly knowledge-based economy. Right, knowledge-based economy. So today, with this internet age, social media age, we all are on our phones, our mobile devices, our computers, our laptops, and so we are always doing research, and learning and, and doing this and that, on our YouTube channels, developing our channels, building our channels, building businesses, building companies, building our brands, Companies are diligent when it comes to identifying and protecting intellectual property because it holds such high value in today's increasingly knowledge-based economy. Also producing value, intellectual property requires heavy investments in brain power and time of skilled labor. This translates into heavy investments by organizations and individuals that should not be assessed with no rights by others. Extracting value from intellectual property and preventing others from deriving value from it is an important responsibility of any company. So in other words, you could be an individual, you could be a company. So companies, they can register, well, when they register their trademark, trademark, trade name, trade secrets, and they register their intellectual property items, assets, I guess I would say assets. It is definitely important for them to do that, to give it gives them protection. In other words, you're running a business and you have, what if you have some books that you have written, in your company, or you have your employees. Now, if your employees are helping you with the books that belong to your company, that would not be your employees' intellectual property. It would be the business's intellectual property. Although it's an intangible asset, intellectual property can be far more valuable than a company's physical assets. For real? Yeah, it could. It definitely could. It can represent a competitive advantage, and as a result, is fiercely guarded and protected by the companies that own the property. I would love to be a company, that owns some intellectual property. Well, I do have some books in the Google Play Store, so I do have copyright to those books. So that is those books would be considered my intellectual property, my creations of my mind. uh, Special considerations. Many forms of intellectual property cannot be listed on the balance sheet, right? Balance sheet, your assets equaling liabilities plus owner's equity. So it says many intellectual property cannot be listed on the balance sheet. That is the initial accounting equation. Since there aren't, they can't be listed on the balance sheet. So many forms of intellectual property, since there aren't specific accounting principles to value each asset. However, the value of the property tends to be reflected in the price of the stock, since market participants are aware of the existence of the intellectual property. So that would be a good field to be into, intellectual property law. Oh, I would love that. Yes, I would definitely love that. My cousin is a lawyer, but he's a criminal defense lawyer. Some intangible assets, such as patents, are recorded as property because they have an expiration date. These assets are recognized by numerical value through the process of amortization. Amortization is an accounting method that decreases the value of an intangible asset over a set period of time. This process helps the company to reduce its income by expensing a set amount each year for tax purposes as the useful life of the intangible asset winds down. For example, a patent might only have 20 years before it's registered as public domain. A company would assign a total value to the patent. Each year for 20 years, the patent would be expensed or amortized the amount by the same amount by dividing the total value by 20 years. Each year, the amortized asset amount will reduce the company's net income or profit for tax purposes. So your net income, so revenues minus expenses is your net income. That is on the income statement. Or profit for tax purposes. However, intellectual property that is considered to have a perpetual life, such as a trademark, is not amortized. I don't know if amortized, whatever, since it doesn't expire. All right, let's talk about the types of intellectual property. Oh, let's talk about the types of this intellectual property. I wish I had a intellectual property lawyer that could come on my panel and speak a little bit more on this intellectual property law. Let me get into it. Let me get into it. So we have the types of intellectual property. We have the patents. You have a patent. You have an invention. That would be a patent. So that is definitely a creation of your mind. That's one of the creations of the mind. You have an invention, like, somebody invented the vacuum cleaner years ago. Somebody invented the television. We have somebody who Alexander Graham Bell, the telephone. Oh, what? Yeah, maybe I'll do another video. Maybe one of my videos will be the next time I'll go over some inventions. Different people that invented this, and I mean back in the day, because we had a lot of people, African American, in the African American, I guess I would say community that, were responsible for a lot of inventions. So maybe that would be a good video as well. Let's talk about these patents. Patent is a property right for an investor that's typically granted by a government agency, such as the U.S. Patent and Trademark Office. The patent allows the inventor exclusive rights to the invention. So you have an invention, you have an invention. You have it. Yeah, I'm talking so fast sometimes. I'm just trying to get through through. I am trying to get through. I guess I'm trying to get through the content. Get it finished. So in other words, somebody invented the vacuum cleaner, somebody invented the telephone, somebody invented the television. So I want to find out. I need to do a video on that to refresh my memory on that. So you have an invention. Somebody invented the fan, a fan. Where to blow the air out. Somebody invented this. Somebody invented that. I said the patent allows uh, the inventor exclusive rights to the invention. Right, you have the exclusive right. You invented it, which could be a design, process, improvement, or physical invention such as a machine. Right. So in other words, we already have vacuum cleaners on the market, but if I could come up with another invention, maybe an improvement, a vacuum cleaner that does something else, TV that can do something else, this that can do something else, that can do something else, and I can make a invention out of it. Technology and software companies often have patents for their designs. Right. So that's why they say it was a question that came about one time. Do companies need patents? Do companies need trademarks? Definitely need a trademark. Do companies need copyrights, patents, and trademarks? My answer would be yes, indeed. If they have inventions, if they have products that they are going to bring to the market, they don't want nobody else infringing on their products or services, then why not? You know, companies have you have companies that probably write their own books, their own movies. You have these film companies. They write their own books, their movies. Of course, they're going to need copyrights for their businesses. Technology and software companies often have patents for their design, right? For example, the patent for the personal computer, right? It was filed in 1980 by Steve Jobs and three other colleagues at Apple, right? So Apple definitely have the patent for the computers that they invented. So we have let's see, we have Microsoft, and we have Dell computers. We have Microsoft, and I don't know the other computer company, but definitely, yeah, I would definitely, I definitely know, yeah, they definitely would need patents, copyrights, and trademarks for their business. Businesses definitely need patents, copyrights, and trademarks. Copyrights provide authors and creators of original material the exclusive right to use, copy, or duplicate their material. Right, so like I said, I have a few books in the Google Play Store, and there's many other books by different authors. So, when you put your books in the Google Play Store, they do give you that copyright protection, and also you can get copyright protection, like I said, from the United States Copyright Office, USPTO, United States Patent and Trademark Office. So, you need a copyright, you need a trademark, you need a patent. And I think you can do those online. It may take a while. Authors of books have their works copyrighted, as do musical artists. And copyright also states that the original creators can grant anyone authorization through a licensing agreement to use the work. So that's pretty good. So a copyright also states that the original creators, like me, I am the original creator of several books in the Google Play Store, and I do have some hard copies at home. So as a creator, I can grant authorization through a licensing agent to use my work, to use the work. And so right, copyright to provide the authors and creators of original material. So in other words, if you have a copyright, once you start writing it down, according to my research, once you start writing down your book, and you're writing it on the paper, your name is on it, that gives you copyright protection. But to get more legal protection, you can register it with the, Copyright Office, United States Copyright Office. So you registered with our Copyright Office. So, whether you have a trademark, a patent, or a copyright, you want to get it registered legally. So in case somebody tried to infringe, on your work, then you have the legal protection, in case you have to go to court or something like that. But once you start writing your book down, you are automatically, covered with copyright law. But, get it registered with the Copyright Office, they give you more protection. Trademarks. A trademark is a symbol, phrase, or insignia that is recognizable and represents a product that legally separates it from other products. So in other words, you have a business, like I said, McDonald's, Wendy's, Church's Chicken, Popeyes, KFC, Kentucky Fried Chicken. All of them are different businesses with different business names. So they definitely have a different trademark. They have that distinguishable mark that distinguishes their brand from the next company's brand. So when you go to KFC, Kentucky Fried Chicken, you go there, or you go to Popeyes, you go to Church's Chicken, you go to McDonald's. When you look up at the trademark, trade name, is going to be a distinguishable mark from the next company's brand. So you're not going to be at McDonald's and and then you're thinking about, I'm at Church's Chicken. No, you're at McDonald's because the trademark trade name, the large M with the golden arches spelled out McDonald's, that lets you know that you are at McDonald's, KFC, and they have their different colors. I think KFC colors, I think it's red and white, if I'm not mistaken, red and white, and then they have, they have their, how they have their logo and their trademark is different basically. So their trademark, their distinguishable mark, it distinguishes their brand from the other company's brand, from other companies' brand. Then you also think about, Nike, they have the check mark, and then they have Nike. And so then you have Reebok, they have their distinguishable mark, their brand mark, or their brand name for their business. So we have K-Swiss, Nike, Adidas, we had the Jordan brand. Jordan partnered with Nike, so they all have their distinguishable mark. And so don't try to go and infringe on. Don't try to go and use the Nike trademark, and you create a brand called, you change the name, but we know that's what you're trying to do. But that's how they go. So a trademark is exclusively assigned to a company for sure. Your company, my company, that company over there. We have Walmart, Kmart, Target, those giant retail brands. Or Walmart. Walmart is the largest retail brand in the United States. So you have those, we have Kohl's, we have Burlington Coat Factory, Target. We have Target, Kmart, Walmart, Kohl's, Burlington Coat Factory, so many different ones, but they all have their trademark, their distinguishable mark, the trademark, trade name. Some of them have, some companies have trade secrets, so you can't infringe on another company's trade secrets, because that would be trade secret infringement. Trademark infringement, copyright infringement, patent infringement, and trade secret infringement. So I don't know if that's a term, but I mean, you can, you infringe on another company's trade secrets. That's a problem too. It says a trademark is exclusively assigned to a company, right? If I have a company, Shirley TV, whatever that was, if I had that, if I had a trademark for Shirley TV, wouldn't that be beautiful? Yeah. So if I had a trademark for Shirley TV, and I wouldn't want nobody to infringe on my brand. I would have me a specific mark, made up for my brand. So it would be my symbol, my phrase, my words, my colors, my business colors, So that would be my trademark. I would want a distinguishable, I would have to have a distinguishable mark from another brand. So say for instance, my brand, I have a clothing brand. If I had a clothing brand called Shirley TV or whatever brand I have, whatever products and services I am selling, I would want to trademark my products and services and my business name, So, okay, let me see. A trademark is often associated with a company's brand, right? For example, the logo and brand name of Coca-Cola is owned by the Coca-Cola Company, right? So we have Pepsi Cola. Pepsi Cola, I think they're the same company, if I'm mistaken. Pepsi Cola, PepsiCo, and Coca-Cola. A franchise is a license that a company, individual, or party called the franchise purchases, allowing them to use the franchise name, trademark, proprietary knowledge, and processes. So it's like you are like I was talking about the McDonald's brand, Wendy's, Church's Chicken, KFC. So in other words, I guess I assume that you would have to have permission. Well, that's what it's saying right here. If you want a franchise, say for instance you want to open up a McDonald's franchise, Popeyes franchise, that company would have to allow you. It says the individual party called the franchise purchases, allowing them to use a company's franchise or name, trademark, proprietary knowledge, and processes. So if I want to open up a McDonald's, I would definitely have to make sure I had the right paperwork in order to use the McDonald's name, trademark, proprietary knowledge, and processes. So I want to go get a Church's Chicken restaurant. I have to make sure the paperwork is in order. So a franchise, that's a pretty good business venture as well. The franchisee is typically a small business owner or entrepreneur who operates a store or franchise. The license allows the franchise to sell the product or provide a service under the company's name. So if I want to go out there and create a McDonald's restaurant, I can operate under the McDonald's name, and I can apply for a franchise. So the franchisee is typically a small business owner or entrepreneur who operates a store or franchise. It says the license allows the franchisee to sell a product or provide a service under the company's name. So I can provide a service and sell a product under the McDonald's name, the Wendy's name, Church's Chicken, Popeyes, different fast food restaurants if I wanted to. Examples of companies that use a franchise business model include United Parcel Service and McDonald's. I was just talking about them. Trade secrets. A trade secret is a company's process or practice that is not public information. So it's not public information. They say, look, these are my trade secrets. I have the code to this. I have the code to that. I have the recipe for this. I have the recipe for that. Those are my trade secrets. So you work for my company, those secrets cannot be given to anyone, because that would be, it's against the law to do that too. I mean, it's some type of rights that, the company has to be able to protect their trade secrets. It says, in other words, a trade secret is a company's process or practice that's not public. It's not public information. It provides an economic benefit or advantage to the company or holder of the trade secret. Trade secrets must be actively protected by the company and are typically the result of a company's research and development, R&D, which is why some employers require the signing of non-disclosure agreements, right? So you work for my company, I need you to sign this non-disclosure agreement because you've been working for my company for 5 years and I have a lot of trade secrets that I don't want to get out. I don't want my competitors to know about my trade secrets so they can replicate my trade secrets and be in commerce, making money off my trade secrets. What? No, it's not going to happen. So some companies have you sign non-disclosure agreements. Examples of trade secrets could be a design pattern, like I said, recipe, formula, or proprietary process. Trade secrets are used to create a business model that differentiates the company's offerings to its customers by providing a competitive advantage. Right. So somebody you run a company and you have this recipe for this, you have a recipe for something that's out of this world that nobody else has. And another company, say for instance, your competitor gets a hold of that and puts you at a disadvantage for that competitive advantage. So your competitor that infringed on your trade secret uh, will have a competitive advantage over you. You know. Then we have something called digital assets. Digital assets are also increasingly recognized as intellectual property. These would include proprietary software code or algorithms and online digital content. Types of intellectual property, we have patents, trademarks, copyrights. Your patents would be your inventions, industrial designs, computer code. Duration in the United States is 20 years. Trademarks, we have unique identifiers for a business or its products or services. Logos, brand names, right? Those are your trademarks, your logos, your brand names. Those distinguishable marks that distinguishes your brand from the next company's brand. Because what sense would it make for you to create a trademark? You created a trademark, and it's the same trademark another company has, So that's why they tell you to do your market research, do your research, make sure you don't pick a name that somebody else has already picked and they are using that business name in those products and services in commerce, and then you come over here and you try to use their trademark, their trade name, and you try to make money. They already been in commerce 5 years. They already have a registered legal trademark for that for their mark, for their trademark for their business. Copyright. Also, as long as the trademark material remains active, right? So in other words, you have a trademark, then you have to just keep using it in commerce. You can't, I think it's after 5 years, according to my research, even after 5 years, once you reach the 5 year mark, you still have to just keep it active, keep using it. Because if you have a trademark and you don't use it for a certain amount of years, and then somebody else infringes on their trademark and they come and, they start making money off your trademark in commerce, but they're gonna be like, the court's probably gonna be like, well, you haven't used this trademark. You didn't keep it active for the past 5 years, so you don't have no recourse in that matter. So that's why they say the duration in the United States is as long as the trademark material remains active. Copyrights is the next one in line. Copyrights, works of authorship. You write a book, you write a movie, you have film, you have poems, you have music, you have photographs, you have online content. So we all have online content. Works of authorship, including books, poems, films, music, photographs, online content. Duration is 70 years after the author dies. Just imagine you write a book, or you write some books, and there's still you still have the copyright protection 70 years after you pass away. The author passes away 70 years, and it still would be protected under copyright law. That is one form of intellectual property. So getting into intellectual property law, intellectual property infringement attached to intellectual property are certain rights known as intellectual property rights. These are rights that cannot be infringed upon by those without authorization to use them. IPRS IPRSs give only the ability to bar others from recreating mimicking and exploiting their work. Right, so you want to be legally protected. United States Patent and Trademark Office. You can do that online too. You can apply for you can legally register your intellectual property. Patent infringement occurs where a legally protected patent is used by another person, company without permission. Patents filed before June 8, 1995 were valid for 17 years, whereas patents filed after this date are valid for 20 years. A lot of times they do be changing a lot of laws. Uh, Copyright violations occur when an unauthorized party recreates all or portion of an original work, such as a work of art, music, or a novel. The duplicated content need not be an exact replica of the original to qualify as an infringement. So that's important right there. The duplicated content need not be an exact replica of the original to qualify as an infringement. So you can infringe on somebody's copyright, and it doesn't even have to be an exact replica. But if it's similar, and I guess they have to probably go through some. I guess they have when the copyright office is checking it out, they look at probably certain things and like, oh, this is an infringement. So it doesn't have to be it doesn't have to be an exact replica. See, copyright violations occur when an unauthorized party recreates all or a portion of the original work. So in other words, I have my books in a Google Play Store, and I do have hard copies at home. So those are ebooks in the Google Play Store. And if somebody recreates even a portion of my original work, I can get them for copyright infringement. Let's go down to trademark infringement. So we have patent infringement, patent infringement, copyright. When they say copyright, well, it's still copyright infringement, trademark infringement, and patent infringement. Trademark infringement occurs when an unauthorized party uses a licensed trademark or a mark resembling the licensed trademark. So you can infringe on somebody's mark by using if you use a mark that resembles their mark, use something that resembles their mark, resembling the licensed trademark. For example, a competitor might use a mark similar to its rivals to disrupt business and attract their customer base. Also, businesses in unrelated industries may use identical or similar marks in an effort to capitalize on other companies' strong brand images. It's just somewhat, a lot of times there's so much going on in the business industry. Trade secrets are often protected by NDAs. When a party to the agreement discloses all a part of a trade secret to uninterested parties, they have violated the agreement and infringed upon the trade secret. It is possible to be guilty of trade secret infringement. Trade secret infringement. I say that I didn't even think that was a word, but trade secret infringement when an NDA is not present. Avoiding intellectual property infringement. Avoiding intellectual property infringement. Let me see. All right. Let me play this video here. Let's see.
Music, writings, movies, and even software. Using a trademark to cover unique branding and identifiers like business names, logos, slogans, mascots, and more. Keeping something secret. Trade secrets make sure that things like manufacturing processes, formulas, and compilations of information never make it into the wrong hands. Getting these protections in place may seem difficult or time-consuming at first, but protecting yourself is well worth the time and effort, and it's not as hard as you may think. This is where technology transfer, or T2, comes in. T2 helps negotiate the use, sharing, and assigning of IP so that companies and individuals can use government technology, or a joint project between the government and private sector can take place. T2 can make it easy to license a patent or share confidential information so both parties can help each other solve problems or create new products. Intellectual property, or IP, refers to something a person has either thought of or created. Some examples of IP include designs, processes, songs, logos, discoveries, symbols, and even brand new varieties of plants. IP belongs to the person who thought it up or put the work into creating it. They get to decide who makes it, how and where it's used, and who can sell and profit from it. But how can thinkers and creators keep their IP safe from misuse by others? After all, in a digital world, it's easy to copy an idea or a design. Luckily, there are laws in place to protect IP once a person is ready to go public with it. There are 4 major paths to legal protection. Applying for a patent. Patents cover things like inventions, new processes, new machines, and new ways of manufacturing things.
Identify your brand on the next company.
Business names, business logos, things like that. Things
Business
that
products
we see
and services.
we know the source of that product or service.
Right.
That's a trademark. And a trademark can be really anything that is used to signify the source of a good or service. So again, this can be words like a name, or symbols like a logo, even designs like trade dress is a trademark as well. Trademarks can also include sounds or smells. Again, anything that is used as a source indicator for the goods or services is a trademark. And the trademark, having trademark rights, is going to prevent your competitors from using the same or similar trademark for same or similar goods or services. Trademark gives you ownership over a word or a design or something. And that's true, but only to an extent. With a trademark, you don't have carte blanche, blanket ownership over that trademark. Your rights really only apply to how you use it in your goods and services. So if someone else wants to use a similar trademark for a completely unrelated business or completely unrelated goods or services from how you're using it, then that trademark rights and that trademark protection may not cover that additional use. So the point is that the trademarks are really specific to how you use it or how the trademark owner uses that trademark, rather than being just a blanket ownership of the word or the mark itself. Now, trademarks can potentially last forever. They can be indefinite. Once a trademark is registered, as long as the trademark is continuing to be used and those renewal filings are made, then the trademark can last indefinitely. And again, just like with copyrights, trademark rights exist under common law as well. As soon as you start using a trademark in commerce for your goods and services, under common law, you have trademark ownership and trademark rights, typically in your geographic area and specific to the goods or services that you're using. So those rights do already exist, but they're much narrower and much weaker than the rights that would exist if you had a federally registered trademark with the USPTO, the US Patent and Trademark Office. So when we talk trademarks, we're talking words, symbols, designs that are used to signify the source of a good or service. Copy it, copyright. It's the right to copy.
Right,
the
to
piece of
copy,
work
right.
And copy it or distribute it or modify it or use it in other ways. Those things, those rights apply to the copyright holder. However, registering the copyright with the U.S. Copyright Office gives you another level of protection over your copyright.
Right,
and it also
you have to go to
gives you
court.
additional rights
infringe on your copyright.
if there's an issue of copyright infringement.
Right.
So the thing to know for copyrights is that it applies to original works of authorship, creative works, works of art, things like that. It lasts for the entire duration of the author's lifetime plus 70 years. The second type of intellectual property is trademarks. A trademark is any word, symbol, design, device, or any kind of combination of those that are used to identify the source. Property. What is it? It's an intangible asset. It's a thing. It's a piece of property like any other property. When we're talking about intellectual property of a business, this is an asset of the business, just like the business's real estate or equipment or any other asset they may have. Intellectual property is one of those assets. That protect creative works, works of art, literary works, things like that. Typically, a copyright will last for a pretty long time. In most cases, the copyright lasts for the entire life of the author, plus 70 years after the author dies. And when I say author, that means whoever created the thing, whoever created the work that the copyright exists in. Once that person dies, then the copyright exists for 70 years following their death.
Wow,
now,
that's a long time, ain't it?
There are common law copyrights, and then there are federal registered copyrights. A copyright exists under common law as soon as you create that original piece of work. So without doing anything else, if you paint a painting or if you film a movie or record a song, as soon as those things are created.
Right, as soon as those things are created, then you have the copyright protection. So let's get back into it. Let's get back into it. Avoiding intellectual property infringement. Infringement is often done unwittingly to avoid being sued for infringement or infringement on intellectual property. Make sure that your business is not using copyright or trademark material, and be sure your brand or logo is not too similar to that of others that it could reasonably mislead somebody to think it was the other brand. Yeah, like when I was talking about McDonald's and the fast food restaurant, and then I talked about Nike and Adidas and Reebok. So if I wanted to create a shoe brand, but I have to make sure in order to avoid intellectual property infringement, if I created a shoe brand, I don't want to make my logo and my labels and my packaging and my whole branding similar. I don't want to make it similar to the Nike brand or the Adidas brand, the K-Swiss brand, or any of those shoe brands. I don't want to make it similar to make people think that it is their brand. That is, they said that it definitely is. There could be, intellectual property infringement. It's also a good idea to, in other words, you should always have to me, I would definitely have my own ideas. You want to have your own idea. You want to have your own creation, your creations of your mind. Be creative. We all have a gift and we all can be creative. I don't want to go create a brand that's going to look like the Nike check I mean, I've seen some brands, but the name is different, but they try to make the check, similar. But I'm saying, you have to be careful with that. So it's also a good idea to do a patent search. Right. So go to the U.S. Patent and Trademark Office, USPTO. Right. You can do a search on the a patent, some patents or copyrights or trademarks to see who has this particular trademark. What company has this particular trademark, this particular patent, or this particular copyright. Uh, so you can, avoid creating your brand under the umbrella of somebody else's brand, or just to look like, something. You don't want to make nothing that's similar to another company's brand. You don't want to copy their trademark or their patent or their copyright. You don't want to copy it. Infringement is often done unwittingly. It is. Sometimes you can do it without knowing. I guess that's what they're saying, to avoid being sued for infringement on intellectual property. Make sure that your business is not using copyrighted or trademark material, right? And be sure your brand or logo is not too similar. Yeah, make sure your brand or your logo is not similar to another brand, to another company's, trademark logo. It's also a good idea to do a patent search. So I read that. There are intellectual property lawyers who specialize in this process to make sure that you are not using anybody else's protected intellectual assets. If you hire somebody to do creative work for you or your company, make sure the contract explicitly states that any creative work that is generated becomes the property of the company and not the person you hired. For example, of intellectual property, there was a widely publicized intellectual property case in 2017 in which a company called Waymo sued Uber over alleged stealing and implementation of technology relating to Waymo's self-driving car program. The plans for the technology, although not yet completely viable, constituted significant intellectual property for Waymo. When they alleged that Uber had obtained their intellectual property, they were able to take action through the court system to attempt to keep Uber from utilizing the information to enhance their own self-driving car program. And what are the four main types? What are the four main types of intellectual property? Yeah! What are the four main types of intellectual property? The four main types. You got your patents, your trademarks, your copyrights, and your trade secrets. Who owns intellectual property? I do. I definitely do. A lot of people. We have billions and billions and millions of people in the world that own intellectual property. The creator of a work is generally deemed to be its owner. However, intellectual property ownership can be determined differently for different types of property and under varying circumstances. For example, if work is created for an employer, right? If you are creating a work for an employer, it is not going to be your copyright. It's going to be your employer's copyright. Mm-hmm. Or patent or trademark or whatever. So it says, right. So it says, for example, if work is created for an employer, you're in an ordinary, under the ordinary course of business, you're working at a job, and you're helping the company create their patents, copyrights, trademarks, so it would not be yours. It would be the businesses. See, the employer is the owner, right, of that intellectual property. Also, ownership rights can also be transferred to other parties. Ownership rights can be transferred to other parties. It says, what's the purpose of intellectual property? Intellectual property can be used for various reasons, such as branding and marketing, as well as to protect assets that give a competitive advantage. Right. Branding and marketing, right? Because marketing gets your products and services out to the public, where people can see it, so your specific branding, your specific marketing techniques gives you that competitive advantage. It protects your assets. In other words, if I have any business, we have so many businesses out here in the world, uh, Walmart, Kmart, Target, Kohl's, Burlington, Coat Factory. We have different malls that have, tennis shoe brands and clothing brands. So we have so many different companies, so many different brands out on the market. So branding is important. Your branding is everything. This company's branding, uh, most likely is going to be different from another company's branding. So your branding is different from mine, and mine is different from this one, and this one, and this one, and this one. It says such as branding and marketing. So in other words, your intellectual property is definitely a differentiator for you in the marketplace in whatever industry you are in. When it comes to other businesses, it says such as branding and marketing as to protect assets that give a competitive advantage. Yeah, because you want to protect. In other words, you have certain products and services that you are marketing and advertising and promoting in your brand. Then we have another business a mile away, or it could be 2 miles away. It could be around the corner. They have their intellectual property as well for their businesses. For their business, intellectual property can be used for various reasons, such as branding and marketing. So when you're branding, your branding is everything. Branding, my definition of branding is everything about your company, your logos, your labels, your trademark, your business products and services, how you treat your customers, just everything. Everything about your company is part of your branding. It says the bottom line, assets come in many shapes and sizes, but some don't have a physical presence. Other often called intangible assets. However, intellectual property ownership can be determined differently for different types of property and under various circumstances. For example, if work is created for an employer, the employer is the owner of the intellectual property. And it says ownership rights can also be transferred. Right, okay, I read that. What is the purpose of intellectual property? Okay, the bottom line, assets come in many shapes and sizes, right? Often called intangible assets. Right, your intellectual property would be your intangible asset. Intangible means something that you can't touch. Tangible you can touch, like your houses, your cars, your land. Those would be tangible assets that you can, your equipment, your business equipment, things that you can touch. Those will be your tangible assets. So then, according to this article, they say your intangible assets are even more, they are more important than your tangible, your tangible assets. So your intangible, intellectual property assets, we have logos, brand names, which can be patented and trademarked. Right, your logos and your brand name. Right, you get a patent for your trademark. You get a patent for your logos and your brand names. It says your logos and your brand names can be patented and trademarked. Help consumers recognize popular companies and their products better. Because if you looking for the Nike brand, and then you're not going to go over to the K Swiss brand or the Reebok brand because you're going to look at their distinguishable mark, their trademark, their trade name, trade name, business colors. For 9 times out of 10, the business colors are going to be in the trademark. In the logo and the trademark, it says logos and brand names which can be patented and trademarked, right, and help the consumers. It identifies that there is a company's identifiable mark, your logos, your labels, like your brand name, your products and your services, all can be trademarked. So those are part of your intellectual property. That's why it's important for companies to take the necessary steps to protect these assets so they aren't misused or infringed upon by others. So the article is, I think this is the last section, strategies to help minimize investment taxes. So I don't need to go into that. That's something different. Let me see. Yeah, that's something different. So this was a pretty good article. It took me into 1 hour, a little over an hour. So intellectual property, right, your literary inventions, literary and artistic works. So your inventions will come under your patent, literary and artistic works, your paintings, uh, books or something that you may write, films, movies. So we have designs, symbols, names, and images used in commerce, performances of performing artists, photographs, and broadcasts. So I think I'm gonna end this live. Didn't want to make it too long. I just wanted to get a little more information on intellectual property. So intellectual property law would be a good field to go into. I would love to go into intellectual property law. I like intellectual property. There's so many different areas of law. In criminal defense, like I say, my cousin is a criminal defense lawyer. I love criminal defense. I love tort law. It's just so many different areas. Yeah, so I love intellectual property law. I like this is so. Matter of fact, let me do something real quick before I shut down. Let me see. Let me go. How many areas of law are there? So this is over 70 core areas of law, which are broken down into 260 sub areas of law. There are many areas of law, and the number varies depending on the source. Here are some examples of the number of areas of law from different sources. So let me see. I know it's more. They say 70, but right here it said 21. Okay, let me go to Wikipedia if I can give you all of them. We have administrative law, admiralty, admiralty law, or maritime law. I think that deals with the law of the sea, adoption law, agency law, alcohol law, alternative dispute resolution law, animal law, antitrust law, art law, aviation law. I don't went off all up in something else. I'm just interested. It's very interesting. Aviation law, banking law, bankruptcy law, bioethics law, business law. I did take a business law course down Straight University, right here in the United States of America. 1 year. So, we have business organizations law, canon law, civil law, or common law. Yeah, I like civil law. So civil law, you find out civil law and the differences between civil law and criminal law. So civil law comes under lawsuits and stuff like that. Then we have common law, class action litigation, communications law, computer law, competition law. Wow, I like constitutional law too, construction law. Like I said, conflict law or private international law, consumer law, contract law, copyright law. Wow. Corporate law, criminal law, like my cousin is a criminal defense lawyer, cryptography law, cultural property law, custom law, cyber law, Well, I guess if they have cyber law, they have oh no, I can't say it. I can't think of it right now, but cyber security law or something like that. Defamation law, drug control law, education law, elder law, employment law, energy law, entertainment law, environmental law, family law, financial services regulation law, firearm law, food law. Right, food law would be good to go into because you probably learn all about the different, uh, well, you learn about the different foods and all the laws that govern, when it comes to companies selling food or, I mean, I guess if they go into some, it's probably a wide range of information that you can learn. Food law, firearm law, that would be a good law to go into. Firearm law, that you can, it's not just about using, being able to have like our second Amendment right to bear arms. We'll go into a whole lot of other information when it comes to firearm law, gaming law, health and safety law, health law, housing law, immigration law. Immigration law sounds interesting. Immigration law, insurance law, intellectual property law. Yeah, I love that. I like that. I like immigration law, civil law, intellectual property law. Those would be my biggest choices. And criminal law, international human rights law, international humanitarian law, international trade and finance law, internet law. Internet law sounds interesting. Labor law, landlord and tenant law. Yeah, so we all deal with that. We have litigation, martial law, media law, medical law. But medical law, that would be a good field to be into. Medical law, military law, mining law, mortgage law, music law. Wow, nationality law, obscenity law, parliamentary. Now these would be some. Now, if I did videos on all these laws, that'd give me plenty of content. Obscenity law, parliamentary law, patent law. Oh wow, patent law, right? Patent law, copyright law, trademark law, poverty law. We have privacy law, procedural law, property law, public health law. Wow, public international law, real estate law, securities law, space law, sports law, statutory law. So the statutes are the laws. So I guess you'll learn about different laws, when it comes to statutes, statutory laws. The statutes are your laws. So statutory law, you learn probably about a lot of different laws, Sometimes laws change, Tax law, that's a good one. Technology law, that's a real good one. Tax law, technology law, like I say, tort law. Tort law, civil law, criminal law, transport law, transportation law, trust and estates law, and water law. Wow, there's so many. Oh, that'll take me a time. I need to just print that out. But I'm going to end this video. I didn't want to make it too long. So, but what is considered your intellectual property? Your intellectual property, your creations of your mind, creations of the mind, So, intellectual property. So I'll probably do some more videos. But sometimes certain subjects take more than one video. So 1 little hour video on intellectual property, and it's still so much information that I want to bring to my channel when it comes to intellectual property law. And I have all these different areas of law that I just read. And some of these I'll be doing some videos on as well. But I want to say thanks for joining me. Glad to see you. Glad you could be here. Glad you could join me.
Intellectual property, or IP, refers to something a person has either thought of or created. Some examples of IP include designs, processes, songs, logos, discoveries, symbols, and even brand new varieties of plants. IP belongs to the person who thought it up or put the work into creating it. They get to decide who makes it, how and where it's used, and who can sell and profit from it. But how can thinkers and creators keep their IP safe from misuse by others? After all, in a digital world, it's easy to copy an idea or a design. Luckily, there are laws in place to protect IP once a person is ready to go public with it. There are 4 major paths to legal protection. Applying for a patent. Patents cover things like inventions, new processes, new machines, and new ways of manufacturing things.
All right, I'll see you all on my next video. So you all have a good one. Yes, so don't forget to subscribe, like the video, subscribe to the channel, and I'll see you on my next video. So go and get your intellectual property. All right, registered. Have a good one.